Great people, how are you doing? Welcome to another beautiful session. Thank you for always watching this channel. Thank you for always tuning in. It's a great pleasure to know that people see these videos I create, this great content. It's a pleasure to see that most people learn from the content I share on this platform. I'm your girl Mercy. I'm glad to be here today, and we're going to talk about a very important issue. Most people know about it, most people do not also know about it. Anytime I create content, I'm happy that I can support someone out there intellectually. I'm happy because someone can listen to watch the video and get one knowledge or the other. You improve even if you don't know anything. At least watching the content can help you, grab one or two things. Just a great pleasure for me that I can contribute, uh, you know, to someone out there, and also I'm helping in the growth of the legal profession. I also encourage you, anything you can do to support a profession, please do it. It doesn't matter how small, it might not be on this platform, it could be physical, do it. It's more like sowing a seed. And I know that this our profession cannot really grow if we are not doing anything on our own part to see that it is growing. It's not left for the people at the helm of affairs. You and I can make difference in a little way we can. So today we're going to take it easy, we're going to take it slowly because this topic is not something I want to rush through, in as much as I do not want to. It's a lecture, yeah, but this lecture will spur you to go back to read because I might not be able to say everything, but I'm going just to run through it so that you can even while sleeping, you can just rehearse or recite what I have said. So sit back and listen. For my returning subscribers, I always appreciate you. You've been amazing, you've been great. Thank you for subscribing to this channel. You're one of the reasons that when I want to, when I'm tired, even when I don't want to create any content, but I say, oh, my subscribers will be eager to get a notification. I, I'm just pushed to create content. Thank you very much. For those who have not subscribed, please do subscribe to this channel, support your girl, subscribe to this channel, like this video, drop your comment. I love to see comments. Please drop your comments. There are maybe things or you felt I didn't ask. You can drop it as a comment or words of encouragement or even criticism. I'm not averse to criticism. I wanted to drop it on the comment section, and if it needs me to reply, I will reply. I believe that teaching should not be that in that old format where sometimes people are sleeping. I try to teach in a different way so that even when you might not really be paying attention, but you will get something. I am on the I'm a fan of the remodified teaching style. So let's get to work. So today we're looking at the law on interim injunction. Hmm. As a lawyer, there are tools that we know. People call it tactics. People call it ways to get it right. People call it what I say, the master strokes. No, understanding the law injunction is important for every lawyer, especially if you are into litigation. You must understand the law injunction. You must understand it appropriately. Yes. Um, so let's get to work. Now, when you hear the word interim, just means literally less complete part of something to be given in full later. It just means an injunction granted meanwhile. Let me give you something. I expect the bigger part of it later. Yes, I'm just trying to make it easy for you to understand. Now, we know you have interim injunction and interlocutory injunction. These are two types of injunction. We have other types of injunction, the perpetual injunction, the Mareva injunction, and or Anton-Pillan injunction, and the likes. But today I'm going to dwell on interim injunction. Um, there are cases I'll be calling out. I may not really dissect the cases just for you to go, because some of these cases are locus classicus when it comes to interim injunction. You know that maybe you don't know the difference between interim injunction and ex parte and interlocutory injunction. One is that in interim injunction it is always granted ex parte, while in an interlocutory injunction it is granted on notice. It means that because of the underlying factors uh, that is making someone to bring an interim injunction, the other party is not put on notice. So why for interlocutory injunction, the other party is put what on notice. Um, let me also explain that when you hear the word ex parte in our adjectival law generally, it means proceedings on behalf of one party, one interested party, without notice to the other party or in absence of the other party. Just like I earlier said, interim injunction is brought ex parte. It is heard by a trial judge in the absence of the adverse party. I've tried to explain that interim injunction is granted ex parte, why interlocutory injunction has to be on notice. The other party has to be notified of the application, and most of the times, almost all the time, they object to that of that injunction and interlocutory injunction by way of filing a counter affidavit and a written address. So they have opportunity to respond. But for interim injunction, which is granted ex parte, the other party is not aware of the application and cannot respond, not because they are not aware, they cannot what respond. Um, Now, interim injunction most times they are not synonymous, because they are quite different. You know, because by its words, interim is interim in nature. And I will explain to you that it's granted ex parte and in emergency situation. Why interim injunction is granted pending the determination, of a substantive suit or an appeal. Interim injunction is granted, pending the determination of the suit. While the suit is going on, someone can bring an interlocutory injunction, or most of the times in practice, it is always filed along with the processes. And maybe the first two adjournments, you see, counsel will want to take that application for interlocutory injunction, which is basically to protect the rest and for parties to maintain status quo. You know, so I'm going to I made some judges. So I'm going to just run through it so that we can understand it properly. Um, I would say that interim injunction most times is not always granted as of right. There are factors, there are essentials, there are ingredients, there are features, there are things you need to prove to the court before the court can grant this type of injunction to you. Because over time, there have been protests, there have been people have raised their voice, and then the incessant nature of courts granting interim injunctions. And most of the time, you see that in where there is a contested case, or most times in maybe pre-election, you see different courts granting injunctions, or sometimes you've heard maybe for example, maybe you see maybe a community wants to crown their king or something, someone can get an interim injunction stopping the occasion. Most times we're also seeing maybe where parties, there are instances, but I'm just giving this instance where that you understand, where maybe a political party wants to do their convention or appoint some executive, someone has rushed to court to get an interim injunction or to stop that event from happening. um, I must say that naturally, just as earlier said, that the purpose of the interim injunction is to, maintain, is to preserve the rest, and in terms of emergency situations, you know, it's this. Some people will say the sole purpose is to keep matters in status quo until trial. Yes, to keep matters in status quo until trial. You see that as much as it is to keep matters in status quo, um, it is always gotten behind the other party, because to avoid issue of this person is responding and this person is not responding, and most at times maybe there is difficulty in serving the other party, or there is imminent danger and you have to avert it, so you need to the court to grant it, so that parties will maintain status quo before coming properly before the court to now hear the interlocutory injunction. you know to keep matters. No, do not forget that one of the essence of interim injunction is to keep matters in status quo while the case is still pending. Generally, the essence of an injunction is to protect an existing right or a recognized right of a person from unlawful invasion by another. So this is important. Now, the jurisdiction of the court, you know that even magistrate courts, yes, can even be grant, they can grant an injunction as depending on the circumstances of the case and the case before them. The High Court has the requisite jurisdiction to they have enormous powers. The High Court has enormous powers to grant injunction in deserving cases. You must also understand that the appellate courts, that the Court of Appeal and the Supreme Court, can grant injunction in exercise of their original and appellate jurisdiction. Everything depends on the circumstances, but they are permitted, they are empowered to grant injunction in their original and appellate jurisdiction, in line with the Constitution. You must also understand that there are one or two, let's say, limitations, you know, because it's not advisable for a court to rush to grant an interim injunction. They have to look at, just like I earlier said, they have to scrutinize the circumstances of the case, so that they will not want to put this maybe the public or the society, or when they feel that, when the courts feel that by granting this interim injunction will cause more damage, they may not grant it. But if you can prove to them that they need to grant it, I've placed the facts before you, I've satisfied I've satisfied all the factors, all the things I need to satisfy, we can grant it for you. And in the court, in exercising its discretion in granting it, must exercise it judicially, which is and judiciously. Um, Now, in practice now, uh, to bring an application for interim injunction, just like I told you, is ex parte. You head it properly like a motion, just that you're not going to sack the other party. Yes. Then you state the prayers you're asking the court for. You seek the prayer. What are the prayers? You know, Remember that you head it motion ex parte, gross portion to order, so and so. You also include the section of the Constitution, sub 6, section 6, or section 36, depending on the nature of the matter, and the orders of the rules of court you're relying on. And you have to know that, of course, be under the hearing jurisdiction of the court, to take notice, or not to take notice, ex parte, because it's not a notice, to do ex parte. This honorable court will be reached the normal way. You draft a motion on the dash day of dash in the forenoon, or so soon thereafter, as counsel for you are the applicant. You state can be heard for the following orders: an order of interim injunction, restraining, because it's always aimed at restraining, so that something will not spoil, the rest will not be protected, there will not be violation of the rights and all of that. Now, The prayers and order for interim injunction, restraining so and so person from. You state exactly what the orders you want the court to make for you. State it. Another of restraining so person from doing this and doing that. You just state it as it is. You know. Now you're not directing the court to maintain a status quo and suspend all actions, all depending on the circumstances of your case. Just like a normal motion, you draft it, then you put in the omnibus ground, omnibus prayer, which is for further orders that the court might be deemed fit. Because the court might look at the circumstances and say, I need to make an extra order so that so that's the reason for that omnibus prayer. Then you date it, put in your signature, your details. Remember that there is no for service form because you're not serving the other party. Then there should be an affidavit in support of the motion ex parte, wherein you state, like a normal affidavit, you state the details, the prayers you're seeking for, why you feel the court should grant uh, the prayers you're seeking for. The affidavit should be detailed. You state the emergency situation, the whole features, you state all of them so that to sway the mind of the court to accepting to grant your prayers. Then you do your written address and there's an affidavit of urgency to state how urgent it is. State the affidavit and state the urgency or the emergency as it is. So then you file. And because sometimes you see, even during vacation, you know that there's vacation courts and all of that, they will sign it immediately and it's heard. Um, at the point sometimes when there is an interim injunction like this, it is even heard before the matter starts. Yes. You know, while filing your other processes, you file it together with the interlocutory injunction. But the interim injunction will be heard first because of the nature of what is at stake and all of that. It's important for any lawyer who wants to understand the law on interim injunction to read the case of Kotori against Central Bank of Nigeria. This is a locus classicus. You know, on interim injunction, it's what the Supreme Court, you know, the revered jurists at the Supreme Court, all of them gave incisive opinions, you know, concurring the lead judgment. So you must read this Kotoye and CBN. It's a very important case on interim injunction. It explains it all. It's, you know, there was in-depth analysis on interim injunction. Is a 1989 case, but it's still referred to till date. 1989, One Nigeria Weekly Law Report, Part 89, 419. You can also see it has been reported again in 2004, 9 to 12 Supreme Court monthly judgments, Part 2222. You know, um, read this case, you will appreciate the law on interim injunction very, very well because the judgment is classical. The other justices who concord, you know, they not just write, I agree. No, there was their own reasoning, stated out their own reasoning, and it was massive. For each of them, you see, you understand interim injunction in a different light, you know, in a different right. You know, I want to read out some things from that judgment. You know, in that case, they will say the gamut of what the Supreme Court held in terms of interim injunction is that an interim injunction is one that is granted on to last until a named or definite date or until further order pending the hearing of a motion on notice between parties. That is the motion for a colloquial injunction. An expanded injunction, which is either interim or interlocutory, is granted where there is real urgency and it is one of the inherent powers of the court for the enhancement of the administration of justice. Um, Another thing they stated in that case is that an interim injunction is made to preserve status quo until a named date or further order on to an application. I've already stated that. Um, it can be made to avoid an irretrievable mischief or damage. Uh, okay, it can be made where there is real urgency, but not self-induced or self-imposed urgency. You know, so a whole lot was stated in that case. Um, it can be granted where it is necessary to preserve the rest, and where there is danger of imminent destruction of the rest. You know, the applicant must not be guilty of delay. It must be granted. It must not be granted until the applicant, gives a satisfactory undertaking as to damages. But it is just a whole lot, you know, was stated in this case. So you need to read it. Uh, and in that case, the parties, lawyers were also discouraged, counsels were discouraged from filing a loan application of an ex parte interim injunction. I think it's you have to file the whole processes in as much as your interim injunction has to be heard first, but it should not just stand alone. Um, Now, they also discourage abuse of grant of ex parte injunction because as a even till now, it is kind of reduced. But before now, there was this advocacy against this excessive grant of interim injunction because a lot of people use that means to exploit others and present facts that were not true and all of that just to buy time or to do something that is not really legal or justifiable. So courts have been encouraged to not to be eager or not to grant interim injunctions in excess. You know, so that case is great. It's a wonderful case. Like, we've had jurists like Naman JSC, Karibu White, Abaje, all of them made their contributions in this case. So we will not just try and read this case to have proper understanding of the law of interim injunction. I can't come and stain everything here because it might even take us 3 hours because it was in depth. I mean, it was in depth. Now we're going to look at the principles of interim injunction. This is key, or the features of interim injunction. And now these features were gathered from this case I mentioned, Pretoria and CBN. It was at that point that these features were really established and stated in full. So we're going to just go through them and just say one or two things. It's not left for you to read up. Lawyers Info Hub, we are here to share legal tips. We're here to teach law the little way we can, expose you to something so it enables you to go and build on it to become a better lawyer, to have more understanding, more knowledge, so that anytime something comes up, you can stand up to it without even making reference to any book or any statutes or law legislation. You state it as it is. So one of the important features of interim injunction is legal rights. An applicant for interim injunction must have a legal right in the subject matter which he wants to prevent the conduct of defendant to violate. The applicant is saying someone wants to violate this, violate my right, but you have to have a legal right. You have to have a legal right. This is very important because sometimes you see people that do not have legal right want this injunction, and it's not supposed to be so. You know, you must show you have the legal right before it can be granted. Remember that I earlier said that interim injunction is usually granted pending determination of application for interlocutory injunction. That's why I earlier said it that when people file their processes, they file interim injunction first, which is heard. Now, in part of their processes, they also file the interlocutory injunction because as the interim injunction is ending, it's supposed that it is expected that interim injunction will be heard. It will be heard. Um, Now, as the applicant, you must have a legal right. this is very important. This is very important. You know, the court in considering whether to grant or not to grant has to determine the legal right to the claim. You know, in determining the court, like, does this person have a legal right to this thing he's claiming? You know, so it's important that you have a legal right. Now, you have to rely on the strength of your case, not on the strength of the adverse party. You know, before now, it has always been that the plaintiff must show a strong prima facie case that is entitled to the relief. You know, that has been the position of the law in several cases. You know, like the case of let me note it very well. Uh, of the Nigerian Civil Service Union and SN. It's an old case, the 1985 case, 3 Nigerian Weekly Law Report, at 12306. You know, where the applicant must show strong prima facie case. You know, but the disposition of the law that applicants must show or make a prima facie case, a strong one, or a case of probability of success change in the case of Obeya Memorial Specialist. This case of Kotoyo and CBN and Obeya Memorial, you have to read these two cases. There are other cases, but these are the foundation. Most of these principles are based upon. So in the case of Obeya Memorial Specialist Hospital and AG of the Federation, it's also in 1987 cases, but they are still relevant to date. 1987 through Nigerian Weekly Law Report Part CC325. Also, you can also see it in 2003. It was reported again in 2003. One Supreme Court monthly judgment 191. So the position of the law changed in that case. You know, my lords at the Supreme Court revisited the position of the law. You know, to issue of establishing a strong prima facie case. You know, so from that case, the use of this expression probability or prima facie case, you know, in the context of the discretionary power of the court to grant this injunction, you know, was kind of watered down. But the idea is that in as much as you have the legal right, the courts have to see that it's not based on probability, you know, but is there a serious question? Is there a serious question uh, or case to be tried? As applicants, have you raised serious question of law? Yes. Have you raised serious question of law? Not just as a prima facie case. Are there questions of law to be tried? So aside having a legal right, the applicant must raise serious questions of law for case to be tried. Um, a substantial issue, not just academic issues, mixed issues. No. Serious questions of law. Now, the third feature of interim injunction, or the third principle, is preservation of the rights of status quo. Very important. Is that interim injunction, is always applied for a person who wants the rights to be preserved or for status quo to be maintained. I know as judges are under a duty, the courts have under a duty to preserve the rest for purposes of determination of the suit. But if the rest is destroyed, there's nothing again, to for the court to work on. You know, I know rest means a thing. Why status quo is like the previous position. Let's maintain the position we were before we got to this point. Yes. Um, and there are a lot of cases. For example, let me explain uh, one of the dictums of one of the learned jurists of the Supreme Court, Cook at JSC. In let me call that case is Laduni and Kokoyi. It's an old case though. Laduni and Kokoyi. You can also see in 7 Up Bottling Company against Bishop Abiola. It's in 1995 for Nigerian Weekly Law Report Part 389 287 on the issue of the applicant having a legal right which has been violated, and for the for on the and the for the let's say the duty of the court to maintain status quo and avoid the violation or destruction of the rest. So one of the principles we have to bring to board, or you have to state or want to show the court before the court can grant the interim injunction, is that if nothing is done, the rest will be destroyed and status quo cannot be maintained again. So that way, one of these things, when you put it down, the court will look at it and exercise this discretion towards granting your application. Now, they have another principle issue of balance of convenience. There's the effect that the balance of is just to look at the balance of convenience between parties, is who will suffer more inconvenience if the application is granted, and also to reverse the question, who will suffer less if the application is granted. So who will suffer more if the application is not granted? So these are the questions the court will look at and know where the scale of justice will tilt towards. The court will look at to provide this question answer: who will suffer more if the application is not granted? Who will suffer more if the application is granted? So it's the two way the court will look at it and answer the question. Um, in Okay, another thing under balance of convenience, the court will also look at if it's that is now let me talk about a little about interpolatory injunction. This principles also is the same thing that is under interlocutory injunction. The only difference is that interlocutory injunction is on notice. And so under balance of convenience, the court will look at issue of award of damages and other. Will this person be satisfied about the if the award of damages and all of that, will it be an adequate remedy? Will it provide adequate remedy needed for this person in the event of succeeding in trial and all of that? So under balance of convenience, the court also look at the adequacy of the damages to be granted as remedy. Now, another principle of interim injunction is your real audience. Like I earlier stated when defining this concept, that most people come to court under interim injunction. These applications are filed where there is real urgency, there there's emergency, where there's something is about to happen to the Lord, or if the court doesn't do anything, something wrong will happen. The applicant, you have to show real existence, existence of a real urgency, not just a caricature, not just like there's a presumption that's an urgency, or there's a presumption of danger and all of that. you know so it is one of the essence of granting it. You must show real audience, not just a caricature, not a joke. Real urgency. You remember that in the absence of real urgency, the rationale for exporting applications cannot be justified. So also in cases of emergency, is under that same Kotoye and CBN, one of the justices, Caribbean White JSC, he introduced the principle of emergency in granting an interim injunction. Where he said that an injunction should be granted as part only in cases of emergency. Maybe when the property is in danger or about to be destroyed, that will be emergency, not just urgency. That should be emergency. So this is a kind of another let's say another leap in the law of or another growth, another development in law of interim injunction. That aside real urgency, that should be emergency, not just urgency. That should be emergency that is calling for the interim injunction. Also, you have to know that delay defeats interim injunction. The applicant must not be guilty of delay. You can't say something has really happened before that we are now coming, and you took time to come. So, all right, you already caused delay. So why are you also asking for interim injunction? So as applicant, you must not be guilty of delay, because by the doctrine of equity, it's the delay defeats equity. And you know that interim injunction is an equitable relief. So, as an applicant, you must not be guilty of delay. Um, Now, another question is that there should be subsisting action and relief. There must be subsisting action and relief to be found on the principle of interim injunction. Like I earlier stated that you file your processes, then but the interim injunction will be heard first. The first one you file, then the other processes you now accompany with their interlocutory injunction. So there must be a subsisting action and relief to be found for interim, uh, you know, injunction. Then look at the court. Another principle is on the issue of gravity of injury or irreparable loss of damage. The court will consider the gravity of injury, the fact that the loss is irreparable, cannot replace it, or the quantity, the quantum, court looks at it, the irreparable loss or damage, the gravity of injury that would have been caused. These are what the court looks at in granting ex parte injunctions or interim injunction. Um, just to curtail this. Now, at the point of interim injunction, the court is not to deal with the main issue. No, it's not required to deal with the merit of the case. Um, all the applicants have to show is the substantial issue we try, the real questions of law, and at this point, that's what the court will look at, not just the main case, not to go into the merits of the case. You know. Now, the impossibility of bringing motion on notice. Remember that one of the reasons why people bring interim injunction is that they couldn't serve, they cannot, or they don't even cannot locate the other parties to serve him on notice for now, or because of the extreme danger involved or emergency, they cannot serve. So these are the court. The applicant must show that it was impossible to bring a motion on notice, considering the sudden event of maybe what is happening or what is about to happen. We couldn't bring. There's no way we would have served the other party or put him on notice. Now, the applicant has to show an issue of inadequate damages. The applicant has to show that the award of damages will not be adequate enough to compensate him. That if nothing is done and I'm exposed to damages, to quantify it will not be adequate compensation for me. So when the applicant shows that, the court can also, one of the things the court will look at in granting or refusing the injunction. Remember, on the issue of lifespan, interim injunctions are very short. They're very short. I know sometimes 7 days and all of that. Sometimes even 2 days. Just depending, but it's of a short time. It's of a short time, and most times the court might even fix the hearing of the interlocutory injunction at the expiration of the interim injunction. But it is usually of a short time. Now, undertaking as to damages, the applicant must be able to make an undertaking that I will pay damages peradventure my application turns out to be frivolous, vexatious, and abuse of court process. That is very key. Undertaking as to damages, the applicant must say I should be able to undertake that he will pay damages in event his application turns out to be frivolous. So this principle is put in to avoid this incessant applications, direct applications, and all of that. So if you're able to prove to the court, it should be part of even your affidavit that you're willing to pay damages where you're undertaking to pay damages where application turns out to be frivolous. Now, there should not be mere allegation of threat to peace. A mere allegation of threat to peace, there's a presumption, and presuming a mere allegation of is not enough to grant an application for interim injunction. It's not enough. It has to go beyond an alleged threat to be substantial acts or overacts of what threats or short threats, substantial, not just mere allegation. And rumors of threats cannot suffice. Rumors of threats cannot suffice. Now we have issue of special circumstances. If the applicant can show special circumstances to warrant the court to grant the application, the court will grant the application. Special circumstances, that will make the court to grant it. Remember that an application for interim injunction is not as a matter of course. It's not more than a court to grant it. Most times we've seen where it was refused, but the court will only look at the guiding principle, just like all those things I've mentioned, look at it and based on the circumstances involved to know whether to grant this application or not to grant. I've mentioned the principles from having a legal right to the applicant have to rely on the strength of his case, the preservation of rest, that the essence of the injunction was to preserve the rest or maintain status quo, balance of convenience, there's a real urgency or emergency situations, and there's no delay on the part of the applicant. There is a subsisting action. There is an action that is subsisting, not just you bringing the application for interim injunction alone. It should not be a loan application. There is a subsisting action. Look at the gravity of the injury, the irreparable loss. The court will look at the merit of the not look at the merit of the case at the point of giving attending to that interim injunction. The merit of the case should not even be in view. Then there was impossibility of bringing the motion on notice. You have to state also that it wasn't possible to serve the other party or to bring the application by way of motion on notice. Now that damages will be inadequate for you. You also looked at the lifespan of interim injunction is always short, very, very short. And the fact that applicant was willing to undertake to pay damages when his application is frivolous, vexatious, or an abuse of court process. Also, we noted that mere allegation of it or rumors of threat to base, the court will not look at that. The court will look at substantial threat to not just allegation. There are also special circumstances the applicant can state or can can bring to the notice of the court to state reasons why the application should be granted. And the application is not always granted as a matter of course. The court will look at whether the principle have been laid down. The court also look at the circumstances of the case, because circumstances differ before the court can exercise its discretion, which has to be decide judicially and judiciously. Most lawyers are known to be interim injunction lawyers. I don't know why, but they usually capitalize on this injunction to do a whole lot. But understanding the law on interim injunction is key in making, in as a litigation lawyer or even as a just lawyer, you have to understand, because there are situations you find yourself, this will come up, and you have to know, how do I go about it? What are the principles? How does it work? And all of that. So today we're going to just run through it, because I told you that you must read that case of Kotoye and CBN, you must read the case of Obeya Memorial Hospital and Attorney General of the Federation. These two cases are very important. They dissected this law on interim injunction. We look at the reasoning of the Supreme Court justices. It's amazing, awesome, deep, so that you can, even while sleeping, you can teach someone else the law on interim injunction. So it's been an amazing time. It's been an amazing time here. Thank you for always watching this channel. I'm very grateful. I'm very grateful. I do not consider myself even worthy of saying all this, but this is my own corporate responsibility. This is the only tool way I can use to support the growth of this legal profession. I believe in this profession. I believe we can get it right. I believe that lawyers are supposed to be amazing, intellectually sound, diligent, hardworking, effective, exceptional lawyers out there. Research is key in whatever you're doing as a lawyer. So today I know that the little things I've shared will help you in your practice. It will help you in your daily life to become that exceptional lawyer we wanted to become. So it's an amazing time here. Thank you for always tuning into this channel. Share this video. Please hit the like button. Hit it. Keep liking this video. Share your comments, your advice, what your things you need to add, or just something that comes up to your heart when you hear about interim injunction. I want to see it in the comment section. I'm always here for you, creating content for you to support you in any way I can. Tell people about Lawyers Info Hub. Share this video, and I know that as you're supporting me, God also supports you. I'm very grateful. If you have not subscribed, don't forget to hit the subscribe button and share this video. It's been an amazing, awesome time. So at this point, I'll say bye, bye, bye. Stay safe, and observe the social distancing, wear your nose mask where possible, and whenever you're going out, yes, don't forget to have your nose mask. God will save us. I know that He keeps keeping us safe. Do have a great time. Do enjoy yourself. Being a lawyer is not easy, but it is worth it. Thank you very much. Stay safe. Bye.